Thank you. This case management conference is in the matter of case number CFI 087-2022 before His Excellency Justice Nasser Al-Nasser. The case management conference is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Horizons & Co. Law Firm. Lead counsel is Mr. Stephen Docherty, and junior counsel is Mr. Rodrigo Kerr. The defendant is represented by MB Kempt LLP. Lead counsel is Mr. Michael Patchett Joyce, assisted by Mr. Salah Mato.
Welcome. First of all, I think I have an issue with my camera, so the matter will be delayed if I call the IT guys to fix it. So we'll continue without my camera. So we'll start with the claimant and then defendant.
Before I start, can I just check Mr. Patchett Joyce is able to now hear me? I can see that one of the versions of him has disappeared. I think he's on mute currently, but
I can hear you. I can hear you, and
perfect.
am I now off mute?
Yes.
Okay. Thanks so much.
So. Thank you, Michael. Yes, thank you, Your Honour. You may have received or had the opportunity to read the brief note that I produced, which is intended to assist really in identifying what needs to be finalised.
Stephen, you'll have seen. Sorry, well, then, friend, I wonder if I could just check that the court has also received our note, because I think that will help in terms of just narrowing the issues.
Well, actually, I reviewed the claimant's note. I haven't.
Your Honour,
I haven't seen the defendant's note.
The claimants provided a note yesterday, and we responded this morning. And we did check with the registry, who was going to pass a copy to you.
The registry passed the copy, but just 10 minutes ago.
I apologise, because the claimant's note came in rather late, and therefore our response was similarly delayed. I'm sorry, I'm still getting an echo. I don't know what.
Coming from Mr.
Is that better? No. What?
I think when you were speaking, it appears to be coming through Mr. Matu's microphone, and it might be that that's then echoing off your own.
Yes.
But now that you've muted Mr. Matu's microphone, I think that your own microphone is
muted as well.
It's muted.
I'm so sorry about this, but is that better? I'm so sorry about this.
I can hear you, and I don't hear an echo.
My problem is I am getting an echo, and it's very distracting.
I think if you mute
yes,
Mr. Mato's microphone and open your microphone, it would be better, maybe. You can now switch on your microphone.
My difficulty is that the icon has disappeared, and I can't find. Right. I can switch that on now. Is that fine? Can you hear me?
It's clear for us, but do you still hear an echo?
No, and can I just check that I can navigate? Yes, I think I can now navigate and get what I need. Yes, I think, thanks to Mr. Matou's technical ability, which exceeds mine by a measure of quantum measure, I am now with you. I can hear, I'm not distracted by an echo, and I apologize for all of the distraction thus far. Your Honour, if I can just recap more succinctly. My learned friend submitted a note yesterday. Obviously, whether one needs a note for a CMC is debatable, but it was in the spirit of helping the court. We saw what the learned friend had done. We simply sought to respond likewise. And because his note came in yesterday, it was only possible to get our note to the court this morning. So I do apologise, Your Honour, that it's late, but I'm glad that Your Honour has it available. And it's probably simpler in due course for me simply to take you through that note, adding anything which arises from what the learned friend says in the course of his submissions this morning.
Yeah, just let us first hear the claimant, and then I'll give you the chance to respond. Yeah.
Hopefully I won't keep you unduly long this morning. You'll have noted that there are they're not really issues of dispute so much. When it comes to case management, it's issues that need to be finalised, but it relates to expert reports and the trial date. And then at the end, I'll pick up with Your Honour an issue concerning court fees, which the claimant considers an issue that rightly ought to be put before Your Honour for his consideration. Just if I can start by guiding you to the relevant CMC documents so that you have those for when you issue your order. If you go to page 91 of the bundle, Your Honour would find there the case memorandum. That's agreed. That won't require any discussion this morning. Page 96 is the list of issues, and again, that's been agreed, so we don't need to occupy any time dealing with that. Your Honour will also see within the bundle, both parties have submitted their case management information sheets. Those are from pages 101 onwards and 107 onwards. And the relevant aspects of those, just to draw your attention to, from the claimant, we've got an indication that there are going to be 2 witnesses of fact. In the defendant's case management information sheet, it'll be 1 witness of fact for the defendant and quantum experts for both parties. So that's background as to why it is that the parties are agreed on a trial estimate for this case of 3 days, with an additional day to be held in reserve so it can be used if required. And that feeds in then to the case management order, which is in draft, which Your Honour will find at page 159 of the bundle, in which you'll see the remaining paragraphs that need to be finalised and filled in, highlighted in yellow. So it's paragraphs 12, 14, 15 and 20, dealing with dates for expert evidence and trial date. So if I can take those in turn, the parties have reached common ground that they'll have permission to produce expert evidence on the question of loss and damage suffered by the claimants. The prior discussions before the CMC, the initial draft of the case management order, the claimants proposed exchanging expert reports on, I believe it was the 2nd of August, with reply reports following in September, and both sets of reports being exchanged simultaneously. In response to that, the defendant proposed a sequential exchange of expert reports, so that's one after the other, with the claimants producing their report on the 5th of July, the defendants a month later on the 2nd of August, with expert discussions and a joint memorandum and reply reports to follow thereafter. The position this morning is that, in principle, the claimants have no objection to that proposal to sequential exchange. Taking that on board, Your Honour will have seen within the note that I prepared and that you've read, the claimants have proposed a timetable which involves the claimants filing and serving their report on the 5th of July. The only point worth noting there, Your Honour, which we would ask be included in your order, is in slightly altered timing. Normally, of course, the court's deadline would be 4 p.m. Local time. Due to the location of the expert witness, we've requested that could be amended on this occasion to 8 p.m. to allow for a 5th of July submission rather than pushing it back through the weekend to the following Monday. But I just flagged that now because it might need to go into the order you draft, otherwise the default position in the RDC would apply. What we had then proposed is that the defendant would have 6 weeks until the 16th of August 2024 to file a responsive report. 1 week after that, the experts would hold discussions. So that's by the 23rd of August. Following that, there would be a period of 2 weeks for the experts to prepare a joint memorandum by the 6th of September, with reply reports to follow another 2 weeks after that on the 20th of September. Now, I'm sure that my learned friend will come to this. I see that there's been a counter proposal on some of those dates. In effect, it's tightening some of the time frame. So I think that the defendant's expert suggests that it will be in a position to provide its report by the 2nd of August and not the 16th, as we've suggested. In principle, of course, it's a matter for the defendant when it files its report and how long it thinks it needs. There's no objection from the claimant's perspective to that time frame being shorter. We do flag this for reasons I'm going to come on to. It's unlikely to make a difference to when the matter can get on for trial. And so it's really for the defendant whether or not they want that 6 weeks or whether they're content to stick with 4. The other alternative proposal is, I think there's common ground that the meeting of experts will take place 1 week later. A point of difference is when the joint memorandum should be prepared. It's been suggested by the defendants that should be a week rather than 2 weeks. Again, it's not a huge distance between us. In light of what I'm going to come on to say about trial dates, again, we're not sure that cutting the time down, particularly during summer, particularly given expert availability and things that would need to be checked on that front, 2 weeks would probably be more, give a bit more wiggle room to the parties, if I can put it that way. In principle, that 1 week timetable might be possible if Your Honour was minded to keep it as a week rather than 2. The only thing we would ask is that the claimant have the opportunity to actually liaise with its expert and check, for example, given that it's summer, that they're not away during the week when that deadline would fall due. But what we can agree to at this stage is the 2 weeks that we'd already proposed. And where that would bring us is that would leave us comfortably in a position to have concluded the expert evidence for a trial window starting towards the end of the year. And as I'm going to come on to, that, as it happens, is the earliest time that the parties are going to have mutual availability anyway. And that might have a couple of knock-on changes to the draft order Your Honour will find in the bundle. So, for example, if, as we propose, the expert phase is concluded by the 20th of September, the pre-trial review would obviously need to be on a date after that. And so we would suggest that the PTR window probably there is going to open up from the 27th of September onwards, which would give the parties time to comply with progress monitoring and so on. But in light of what the trial dates are likely to be, we would suggest that the PTR should potentially be a number of weeks after that to allow the parties whatever time there needs to be. It gives the parties a bit more scope if extensions are required and so on, without having to vacate a pre-trial review, and particularly where a trial is going to be unaffected anyway. So that's expert report. We would respectfully suggest that the court adopt what I've set out in my note. So that's the period of exchange beginning 5th of July and the process ending on the 20th of September. And the residual issue in the case management order is then trial window. My learned friend has suggested in his note, which I know you haven't had the opportunity to read, but which Mr. Pratchett-Joyce, no doubt, is going to take you through, is that one of the reasons that the defendant has sought to shorten the time frame for expert reporting is to try and get a hearing on in November, not December. Just to be clear on that, our position would be that the process of expert reporting the claimant has proposed would actually already allow for a trial as early as the end of October 2024. The issue with November isn't that the case won't be prepared, it's actually simply a case of party availability. That is a combination of both my own unavailability, but also the claimant's expert witness being unavailable during November. And Your Honour will have seen that the windows that the claimant is available have been proposed in my note. If we assume that November is not possible, we'd be looking at as early as possible, I think, in December. We have offered one window from the 21st to the 25th of October, but I understand that the defendants are not available on those dates. And so that's why that hasn't been able to work. So I think what we would be asking the court to do, having fixed that timetable with regard to expert reports, is to fix a 4-day trial as soon as the court has availability in the first week, ideally, if not within the first 3 weeks of December this year, which appears to be the earliest reasonable date that the parties are going to be able to get the matter before the court. Your Honour, that's all I have to say about the case management directions. The final issue I wanted to draw your attention to was in relation to court fees. And you'll have read what I have said about this in my note. Really, this is a matter which is something which arises that, if it is of interest to the court, is a matter for the exercise of the court's discretion, but which the claimant feels bound to draw the court's attention to its CMC. In effect, the defendant has failed, we say, despite requests, to pay the requisite court fee in respect of his counterclaim. The registry is aware of that issue, and we say the defendant has repeatedly failed to resolve it in what we say is a deliberate attempt to avoid putting up money for his counterclaim. And whilst my learned friend might say this is much ado about nothing, the issue isn't insignificant. In processing any claim or counterclaim, it of course takes up the court's administrative time. It requires the fixing of hearings like this one, and they have costs associated with them, and that of course is why court fees exist. And the defendant has been asked by the registry to rectify the issue and hasn't done it. And if I can take Your Honour through a bit of the background to this so that you're familiar with it. If I can ask you to, first of all, turn up page 145 of the bundle. And if you could let me know when you have that.
Yeah.
Just the procedural history of this claim is that there have been a number of iterations of strikeout and other hearings which have been heard by His Honour Justice Sir Jeremy Cook. leading to orders being made for the filing of the claim and particulars of claim and the defence and counterclaim. The latest iteration of the order being the 30th of October 2023, which I don't need to take you to, but for your notes at 127. What we then have at page 145, but it begins at the end of page 144 and top of 145, is a 5th of January email sent by the claimant solicitors to the registry. You see it begins at the bottom of the page, bottom of page 144. We refer to the order of Sir Jeremy Cook, 30th of October, directing the defendant to file and serve his defence and counterclaim by the 16th of November. We would like to bring the following to the registry's attention. The defendant has failed to file in the required form, so that's form P1601, as required by Practice Direction 5 of 2010. And instead, the defence was filed using the court form other non-standard case-related documents. And in doing so, the effect was that the defendant avoided paying any court fee. The following paragraph sets out what the court's requirements are when it comes to court fees. So where we have a claim, as we do in a counterclaim, as we do in this case, of just over $668,000, what the court fee that would apply in that case is $25,000 plus 1% of the claim amount. And in the final paragraph, we see reference to the fact that that had already been the matter of correspondence between the parties. So we have a situation here where the applicable court fees for the defendant's counterclaim are in excess of $25,000, but what has actually been paid is $1,500. On the 10th of January, if your honour goes to page 144, at the top, we can see that the registry issued its direction, and it said the defendant is advised that a counterclaim will not be accepted onto the court file unless it's sought by way of P1601. So that's using the proper court form to file the claim. We then have an exchange of correspondence, which I won't go through the detail of everything on, but we've got the defendant's solicitors emailing the registry on the 13th of January. That's at page 142. And if I can summarise it, the defendant's position is that it's not willing to pay the court fee until disclosure has taken place. The claimants responded to that on the 18th of January, and that correspondence, if you scroll up, is at 137. It's bottom of 138 and top of 139. Correspondence I'll just draw you to because it points out the relevant court provisions and practice directions concerning payment of fees. Do we say it's directed to the registry? It refers to Practice Direction 3 of 2017, which is the practice direction dealing with DIFC court fees. And it highlights Schedule 1, Article 1F, subparagraph 3, which says that where a claim or counterclaim is amended so that a higher fee would have been payable, if it had been so drawn originally, the party making the amendment shall pay the difference. So that is, if from the point in time you initiated your counterclaim, the pleaded value has gone up, you have to pay the difference in those fees. And that's what the court rules have to say about that. As we continue through this email chain, the defendant responded to that, as I understand it, without permission of the court on the 20th of January. That's at 137. The claimants responded to that again on the 23rd of January. That was with permission, and that's page 134. And following on from that exchange, we find another registry direction, which is at 133. At the bottom of the page. It said, please be advised that the registry of the future emails and directing the following. If the forms have not been amended, the parties are to do so and submit the forms via email for sealing. Additionally, if the counterclaim amount has been amended, the defendant is to immediately file the difference in court fees. So the court, we say, is it's in a pretty clear direction there, which is if you haven't filed the correct form, that's P1601, do it. If you haven't paid the difference in court fees to reflect the amount of the counterclaim, then pay it. Notwithstanding that, the defendant hasn't paid the relevant court fee, it hasn't filed the relevant form. Claimant therefore wrote to the registry drawing its attention to that non-compliance on the 30th of January 2024. That's the correspondence at page 131 on the bottom half of the page. And what that does is it draws the court's attention to the history of how the counterclaim had been articulated, which is that when it was first filed as a counterclaim on the 14th of February 2023, the stated value was 0. However, following the litigation that took place during the course of 2023, we had Justice Sir Jeremy Cook's order requiring the filing of the counterclaim, and it also required the claimant to specify, in effect, what the minimum accepted quantum of the counterclaim was going to be, which I'm going to take your honour to in a moment. But what that does is it revises upwards from the estimate of 0, a specific dollar figure as the minimum claimable amount on the counterclaim. Following that exchange, we have another direction from the registry, which is at page 128.
I wonder, as we're going through the correspondence and documents in this part of the bundle, I wonder if the court could just pause a moment and read what my instructing solicitor said at page 130.
Your Honour, it's obviously a matter for you whether you want to read that now or whether you want my learned friend to take you to whatever he wants to say in due course.
Yeah.
Well, it's just convenient. I just thought it was convenient to read it now, but I'm happy to take the court to it in due course if that's more convenient.
Yeah, I'll give you the chance to respond, yeah, and take me through the documents.
Thank you, Your Honour.
Thank you. Your Honour, then, if I can go next to, and really the focal point here is what the registry is saying at 128, which says, "Dear sirs, please be advised of the registry's direction that the defence with counterclaim previously filed on the e-registry online portal may be amended manually. Thereafter submitted to the registry via email for us to calculate the difference in court fee." So again, what the registry is clearly trying to say is amend your counterclaim form, submit it to the registry, and we're going to calculate the difference in the court fee. But again, what the defendant does is it maintains its position that it thinks it doesn't need to do this until disclosure of documents has been provided. Now, Your Honour, just to take you to the parties' pleaded cases on this, because the underlying issue here is actually very, very straightforward. The admitted quantum of the defendant's counterclaim, so that's if it succeeds on questions of liability, is the amount of just over $668,000 plus another smaller dirham amount to deal with expenses. And we can see that if we go first of all to the particulars of claim at page 28. If Your Honour could let me know when you have that.
Yeah.
And we're looking at paragraph 51.
Okay.
Which is a paragraph that was specifically inserted into the particulars of claim at the direction of Justice Sir Jeremy Cook, who wanted to know on a specifically pleaded basis what the accepted quantum of the entitlements due were, subject to the question of liability being determined. And what paragraph 51 said about that is, without prejudice to contention set out above, is that the maximum quantum of the defendant's entitlement to commissions allowing for deductions, etc., is no greater than and then we have the dollar amount, USD 668,348, and the maximum quantum of entitlement to expenses is 52,000, just over 52,000 dirham. So we have a pleaded amount, which is the amount of the counterclaim. That is then adopted and pleaded by the defendant in its counterclaim. So the next page I want to take you to is page 68.
60?
68.
Okay.
It's paragraphs, first of all, paragraphs 89 and 90, which says the defendant accepts and avers the first claimant's acknowledgement in paragraph 50 of the particulars of claim that the defendant is to be credited with an entitlement to reimbursement of expenses in the sum of 52,000 dirhams, and then asserts the defendant is entitled to be reimbursed that sum by the first claimant. Then paragraph 90 says the defendant further accepts and avers the first claimant's further acknowledgement in paragraph 51 that he is entitled to commission the maximum sum of $668,000. The defendant is entitled to be paid commission in that sum by the first claimant. So we have two paragraphs which specifically assert entitlement to those specific sums. And in case that wasn't clear enough, if you go over the page to 69, Your Honour will find the statement of relief sought.
Yeah.
Says, and the defending counterclaims, specifically in demand, expenses in the sum of 52,000 dirham, commission in the sum of $668,000. If one looks at that, it is frankly unarguable those sums set out as being the defendant's counterclaims are the relevant quantum of the dispute for the purposes of calculating court fees. Based on the way that the DIFC calculates its court fees, the applicable fee here is $25,000 plus 1% of the claim value. So that's 1% of the amount being claimed at recitals 1 and 2 of the statement of relief sought. There is no provision anywhere in the court rules that says that a party is entitled to not pay court fees until after disclosure in the case has taken place. There's a very obvious reason for that. By the time disclosure has taken place, parties have already incurred the use of a significant amount of court time. For example, if there's to be a hearing for a party seeking a document production order, we of course have things like this CMC. We've had a number of other hearings in this case where the parties are extracting whatever value they can from the court, and that is what court fees are for. And so the claimants feel bound to draw the court's attention to the relevant provisions of the court rules, which set out what the court may, acting on its own initiative, do where one has a party who's been directed on multiple occasions by the registry to sort this issue out, but who hasn't done so because they don't want to pay the court fees. And Your Honour, if I can just read those provisions to you, they're all contained in Part 4 of the Rules of Court. So first of all, Rule 4.35 says that the court will serve a notice on the defendant requiring payment of the fee if at the time the fee is due, the defendant has not paid it. The 4.35 is dealing with a scenario where you've got a defendant who has a counterclaim that hasn't paid the fees in their counterclaim. It says the court will serve a notice requiring that payment. 4.36 says that the court should, in issuing that notice, specify a date for payment. So it says the notice will specify the date by which the defendant must pay the fee. Excuse me. And 4.37 sets out the consequences. So 4.37 says, if the defendant does not pay the fee by the date specified in the notice, the counterclaim will be automatically struck out without further order of the court. Well, of course, it's a matter for Your Honour. It's a matter, to some extent, for the registry, but I imagine the registry would take the view that it would be greatly assisted by Your Honour in dealing with this issue, which the registry has now attempted to deal with at least 3 times without success. But it's pretty apparent from both the exchange of correspondence and the way in which forms have been filed in this case that the defendant's just seeking to avoid paying fees associated with his counterclaim. And really, it shouldn't be too controversial to say that he shouldn't be entitled to occupy this court's time and administrative costs without paying the court what's due to it. And whilst it is a matter for the court acting on its own initiative, we would respectfully invite the judge to deal with this matter by issuing a notice precisely as the rules intend. To issue a notice, give the defendant a date by which he should pay his fees, as he is now required to do. And if he doesn't do it, then his claim will be struck out. So that's all really we have to say about that. I'd be happy to come back to Your Honour and assist with any other issues in due course.
Thank you. The defendant may respond. You're on mute.
Your Honour, I'm obliged, and I wonder if I can take you to the note which was furnished today, because it will, I think, cut through an awful lot of what we need to be dealing with. So I'll just get that on my screen, and if Your Honour has a hard copy of it or it in electronic form, then whenever it's convenient, I can take
I do
through.
have a copy. Yes.
I'm very much obliged. But Your Honour, paragraph 1 simply covers a very short point as to whether written notes are necessary for a CMC, but it's certainly convenient. Looking at the second paragraph of the claimant's note, we agree that most of the issues are agreed. And as has been canvassed by my learned friend, the court is in receipt of the agreed case memorandum and the list of issues, and having been taken to the draft order, is obviously aware of the scope of agreement between the parties on the directions. The 3 points which have been covered by my learned friend are covered in the same sequence in the note which I'm taking Your Honour through. So beginning with experts' reports, I put it rather tentatively, it now seems to be common ground. I think it is common ground that there should be sequential exchange of experts' reports, lest that were in issue, but it now, of course, is not. I say that that course is plainly procedurally efficient and as such is both sensible and desirable. And I think we can now move on to paragraph 4, which seeks to summarise the differences between the parties in tabular form. My learned friend said that we had put forward a counter proposal in relation to the timetable for experts' reports. That's not strictly accurate and should be corrected, because of course it was the defendant's legal representatives who suggested and put forward the sequential exchange. And not only did those instructing me put forward that proposal, accompanying that proposal was our proposed time frame. So in fact, in terms of a sequential timetable, ours was first in time. Not that it makes a great deal of difference, but what we've set out in tabular form is the dates to be derived from both the claimant's proposal and our proposal, and in typical schedule style, we've allowed a section for the court's notes and decision. And Your Honour can see those dates. They've been covered by my learned friend, but they are set out graphically in the table. And in paragraph 5, what we've sought to do is to distill or draw out from that table certain points which are clear. So just looking at paragraph 5, the date for the claimant's expert's first report is common ground. It's agreed it should be the 5th of July this year. The claimants are then proposing 6 rather than a 4-week period for the defendant's first report. We have considered the point, and I'm grateful for the indulgence that the learned friend would grant us in this regard, but we do not think that our expert will need 6 weeks in which to produce the first report. So therefore, quite simply, we are proposing that the court should follow our own shorter time estimate, because if anyone's taking a point against themselves, it's us. We're suggesting, and not only suggesting, we're saying that we will do it in 4 weeks rather than 6. The next point, point 3 under paragraph 5, is that it's common ground that the experts should meet 1 week after the defendant's expert has provided the first report, and the parties are again agreed that such a meeting can be held remotely by virtual transmission over Teams or Zoom or whatever is most easy. Point 4, claimants are proposing a 2-week period for the experts to provide a joint memorandum. We have again considered this, and we don't find it at all clear as to why a 2-week period would be needed, because when you stand back and you think about what is the purpose of a joint memorandum is essentially a summary of the points, whether in agreement or whether of disagreement, that will have clearly emerged from the experts meeting and the discussion that will have passed between them at that meeting. So we regard this as really a rather straightforward exercise of reducing to writing what has been discussed orally between the experts. And as such, it's certainly not an extensive exercise. And we would urge that there is actually considerable merit in it being done as close to the experts meeting as possible, because everything's fresh in people's minds. And even a 2-week lapse for busy professional experts may mean that they actually lose sight of something which was said. So on that basis, we say that a 1-week period should be ample, and we've supported the reason for so saying by what we would submit is good reason. And finally, looking at the table, we say it's obviously common ground that the experts' reports in reply should be submitted 2 weeks after the joint memorandum. So in fact, the scope for difference between the parties is, as Your Honour sees, relatively narrow. The 2 points that are in difference have been explained and investigated and discussed in this note, and we would commend the analysis back, the submissions back with the analysis that we've just set out. The defendant does not see why the timetable is at all unworkable, which was the word that the claimants used. Looking at it in the overall standing back and analysing it, we would say that the 3 weeks which are written into the claimant's proposal, 3 additional weeks, really is simply too leisurely. The claimants acknowledge, and we've provided the reference, it's paragraph 8 of their note, that their timetable will push back the next steps until October 2024. They suggest that this will not cause a problem when available dates for trial are not likely to be before December 2024. And of course, this subject is the subject of further comment in the next section. So it may be convenient if I just park that point and return to it in the light of what is set out in the next section of this note. What we say, Your Honour, is that by following the defendant's proposals for experts' reports, the case will be ready for hearing 3 weeks sooner than would be the case if the claimant's proposals are followed. And that, we say, has the obvious time effect of meaning that the case can be listed in November rather than December 2024. Now, I heard what my learned friend said, namely that his expert is not available during November. And he went on to say that he was happy for the trial to be listed as early as possible in December. And I think he said ideally within the first week, and in any event within the first 3 weeks. Well, we would underline the word ideally within the first week of December, and we do so for the reasons which are set out in paragraphs 10 and 11 of this note. We begin at paragraph 9 by saying, as a matter of general principle, cases should be listed for hearing sooner rather than later, promptly and without delay. That's obviously a common starting point. More specifically, we say it is quite notorious that December is a more difficult month in which to list cases than November, and we put it forward again two cogent reasons for that. First is the fact that the first week of December is UAE National Day. It does bring with it holidays granted by His Excellency the Sheikh, and we would need to navigate round that. The second is a desirability, if possible, to avoid the run-up to and period of international holidays, which I obviously have in mind Christmas and the New Year. And the third factor that we would bring into play is that any slippage in the timetable for a multi-day hearing in December is likely to have a more than expected knock-on effect, simply because of the intervention of international holidays, so that the matter, if vacated from a hearing close to Christmas and New Year, it will almost inevitably go over and need to be relisted at some time later in the new year, and that obviously is undesirable. So what we say, paragraph 11, is that in the circumstances of the present case, the court doesn't need to have a weighing exercise or prioritization or looking at how the combined or the individual and combined effects of points 1 to 3 apply, because the simple answer would be to follow the defendant's proposed timetable for experts' reports, which allows more than sufficient time for the trial to be listed in November rather than December 2024. Having heard what my learned friend has said, there is perhaps a clear opportunity for common ground, and if his expert is genuinely in difficulties throughout the whole of the month of November, then as a listing for 4 days as early as possible in December, avoiding the likely period of the National Day holidays, would be a suitable common ground, which seems to me, and I would submit, is an avenue that the court could profitably explore for the mutual benefit of both parties. Your Honour, I now pass to the question of court fees. Learned friend used the expression much ado about nothing. Well, I did wonder about using the expression much ado about nothing, but chose to say more specifically that in our submission, the claimant's case and position in this regard is much ado about their own obstinacy. Now, one obviously wants to create more light than heat, and the word obstinacy is not intended to create heat, but it is intended to illuminate the position that we are in. We say that the position is simple. The position is as follows. The defendant will pay whatever is the appropriate fee. We're not just saying that now. That was why I asked my learned friend to pause when he was going through the documents and allow the court time to read page 130 of the court file, and also the court should have the opportunity of reading page 146. And at the end of these submissions, I'll probably come back and just take the court to those two documents. Those two documents make it absolutely clear that the defendant has said to the registry he will pay whatever is the appropriate fee. So that covers not only the second sentence of paragraph 13, it covers the third sentence as well. However, continuing with what we say in paragraph 13, however, to pay the appropriate fee, the defendant and his legal representatives must know what it is, and the claimants hold that information. My instructing legal representatives, the legal representatives for the defendant, have asked for that information. They've been asking for it specifically in this context since October of last year. The claimants, or doubtless on their advice, or certainly with the knowledge of their legal representatives, have not provided the information. And that leads to a simple conclusion. We don't actually know what the sum to pay is. Let me elaborate on that, because the court has been taken to the amended defence and counterclaim, and indeed before that to the claimant's amended particulars of claim. So the court has seen that the figures that we have sought to pursue in the amended defence and counterclaim are derived from what the claimants have said in the amended particulars of claim. As I say later on in this note, it must be remembered that the defendant was summarily dismissed from his employment in September 2022. So he has no access to any of the underlying material. And that's why he doesn't know what sum there is to pay by way of court fees. Because although he is presently claiming by way of counterclaim for the unreimbursed expenses and the unpaid commission to which he's entitled, he is dependent in both instances on the figures which are within the claimant's knowledge. And as I conclude in paragraph 13, when the defendant knows the amount, he'll pay it. So in perhaps repetition of what I've just said, in paragraph 14, the note, the court should be in no doubt that the defendant wants and intends to pay the appropriate fee. It should be in no doubt that the defendant will pay the appropriate fee. And just to deal with the other incidental matters raised by my learned friend, the defendant, my client, and his legal representatives are fully aware of the relevant correspondence. I don't think the entirety has been included in the bundle, but some of which is included in the bundle at pages 127 to 146, which the court has seen. And also, we're obviously well aware of the way in which we put our case, and I've just expanded upon that when talking to paragraph 13. We're also well aware of the provisions of the RDC rules. But contrary to the claimant's contention, this is not the defendant prevaricating. This is not, as my learned friend sought to characterize it, how did he put it? We were seeking to avoid paying fees associated with the counterclaim. That's not a right characterization. The problem has arisen solely because of the deliberately unhelpful attitude which we've encountered. And we say that a stop should be put to this. Just pausing there to test that, of course, the court has powers under Part 28, and in particular, Rule 2847 to 2850, to provide advance disclosure. An advance disclosure can and is provided for in those sections of the rules, or those parts of the rules, applies before proceedings have commenced. Now, of course, proceedings have commenced here, so we're at a later stage, but one of the express requirements to be considered in an advance disclosure application before proceedings is whether the application is likely to save costs. In our submission, seeking by way of correspondence, as we've sought, advanced disclosure during the course of proceedings, the same sorts of considerations clearly apply. And it must be a saving of costs if the claimants would provide the information which they will have to provide in any event. So if we move on to paragraph 16, and I've almost concluded the written submissions which cover the points in issue, the key, we say, to unlocking the problem is to be found in the claimant's own note for the CMC, because as they seem to acknowledge in that note, well, they certainly acknowledge our concern, and indeed it is a genuine concern that the value of my client's counterclaim may change in light of disclosure. Seems that the claimants acknowledge that is not an unreasonable position to adopt. And here I make the point, as I've already covered, that the court is invited to recall the basis of the counterclaim and the nature in which it arises through the summary dismissal and the absence of access to any of the information which is relevant. So all that the defendant has asked for is disclosure of material and information which must be disclosed at the disclosure stage in any event. Again, we don't make this application, or we don't adopt the position that we've adopted lightly. Standing back, there is very good reason for the claimants to provide the information and material sought. Because every time a party files an amendment, that party must pay a fee. The defendant paid the appropriate fee, albeit that the counterclaim had no monetary sum identified back in February 2023. Now, in the light of information from the claimant's position is now essentially to sit on their hands, fail to make advance disclosure, require the defendant to pay an amendment fee now, whilst even now, at this present moment, the claimants contemplate and countenance the possibility that the defendant will find on disclosure that he has to amend his claim further. And that would incur liability and an obligation to pay another amendment fee. We simply can't see the sense of that sort of arrangement. It is, frankly, grotesque that we should be put in that position. All we've asked for, as I say in paragraph 18, is advanced disclosure of information and material which will enable my client to calculate his counterclaim with proper particularity. That is a perfectly reasonable request, and that is why I've used the word obstinacy. Claimant's failure to respond to reasonable requests made in correspondence does, unfortunately, in our submission, amount to obstinacy, and is, in our submission, the entire root cause of the problem. So, having identified the problem, one turns obviously to the solution. And the solution is simple. If the claimants respond appropriately to correspondence asking for advanced disclosure of matters that will need to be disclosed in any event, that will provide an entire cure. And that will be an entire cure with no need for the issuance of any notices by the court. And when one stands back and looks at this matter in the round, it is difficult to think of a clearer example of matters running contrary to the fundamental principle, the overriding objective set out in rules 1.6 to 1.9 of the RDC. The claimants simply are not cooperating on a matter which obviously invites cooperation. And we say quite simply that should not be condoned by the court. I said, Your Honour, that I would take the court to pages 130 and 146 of the bundle, and I wonder if I can go there now.
Yeah.
It's in section E5, no, section E4 for page 130. This is the email of, one can see from the foot of page 129, that it's an email from those instructing me and acting the defendant's legal representative, Mr. Matu, sent to the claimant's representatives on the 30th of January 2024. Sorry, it's not sent, it's copied to the claimant's representatives on the 30th of January. It's sent to the court registry. So the principal addressee is the court registry, but it's copied to the claimant's legal representatives. It refers to the previous email from the claimant's legal representatives. The defendant's position is as follows. The defendant has no underlying data or documents to ascertain or confirm the counterclaim amounts provided by the claimants. All the underlying documents and data in relation to the defendant's counterclaim are in the possession, custody, and control of the claimants. Your Honour, pausing there, you understand from the background why that bullet point was said. Second bullet point, the counterclaim amount provided in the defendant's defence and counterclaim was provided by the claimants, and they have not yet provided any underlying documents or data in relation to the counterclaim. Third point, the defendant does not object to paying the DIFC court fees in relation to its counterclaim, which is entirely based on the amount provided by the claimants. However, the defendant can only know the exact amount of the commission and expenses, i.e. the counterclaim, once the claimants will provide the underlying documents and data in relation to the counterclaim. We have requested the claimants to provide these documents and data for several months, and they have refused the requests of the defendant. This matter can be swiftly resolved now, and this is a letter which was written back at the end of January. Can be resolved now if the claimants disclose all the underlying documents and data, and the defendant then could pay the appropriate DIFC court fees and amend, confirm the counterclaim figure provided by the claimants. Based on the conduct of the claimants, the defendant has to wait until the disclosure process to receive these documents from the claimants. So it's not that we are deliberately prevaricating and that we are postponing matters until disclosure, and that's contrary to the rules of the court. That is the position that we are being forced into. It's not the position we want to take. We want to pay, and we want to pay the appropriate sum, and we want to pay it as promptly as possible, which I will come on to. So the characterization of prevarication is quite simply wrong. Based on the conduct of the claimants, the defendant has to wait until the disclosure process to receive these documents from the claimants. The delay in relation to this is entirely due to the claimant's conduct. Next bullet point. The defendant does not object to paying the correct DIFC court fees, and if the registry considers it should pay court fees based on the counterclaim amount set out, provided by the claimants, the defendant will abide by the registry's decision. However, at this stage, the defendant has no data to confirm whether this is the correct counterclaim figure. The defendant hereby undertakes that he shall pay, so it's an undertaking given by a legal representative, that the defendant shall pay the DIFC court fees when he can confirm and ascertain the correct counterclaim amount owed to him by the claimants. The fact that the claimants are failing to provide the underlying counterclaim is different. The fact that the claimants are failing to provide the underlying documents and data in relation to the defendant's counterclaim indicates that the correct amount of the counterclaim is different from the amount provided by the claimants in their particulars of claim. It seems an inevitable inference from the position adopted by the claimants that that must be right. Final bullet point. The issue of the defendant's court fees can be swiftly resolved in 2 working days following disclosure of all the underlying documents and data in relation to the defendant's counterclaim. It would not take the defendant more than 2 days to review the underlying documents and data and update its correct counterclaim figure, and then apply to amend its defence and counterclaim accordingly. The claimants can either provide all the underlying documents and data in relation to his counterclaim now, which means the issue of the court fees excuse me, to be paid by the defendant in relation to his counterclaim can be resolved now, or they must disclose these documents and data during the disclosure process, which means the issue of the court fees to be paid by the defendant in relation to his counterclaim can be dealt with after receipt of the underlying documents and data during the disclosure process. Therefore, any assertion that the defendant does not wish to pay the DIFC court fees in relation to his counterclaim is not correct. The defendant will abide by the decision of the registry in that regard. So, Your Honour, that's why I have to take you to this important email in its entirety. Because even now, even though Milena Friend has had this email for a month, he is still peddling inaccuracies in trying to say that this is prevarication on the part of my client. Quite simply, it is not. The other document that I said I would take you to is page 146, which is in the next section, or the next subsection of section E, and it's the first document in that clip. I'm afraid it's in very small print, so it has to be, I have to enlarge it on my screen to read it. Much shorter, but it's quite clear. Dear Registry, the defendant is very grateful for your directions as set out below. The defendant shall manually amend P16 previously filed by the defendant within 2 business days of the claimant's disclosure of all the underlying documents and data in relation to the defendant's counterclaim. This will allow the defendant to accurately ascertain the quantum of his counterclaim, i.e. the amount of commission and expenses owed by the claimants to the defendant. The claimants can either provide the underlying documents and data in question today or during the disclosure phase. As soon as the defendant receives the underlying documents and data to ascertain the correct value of his counterclaim, the defendant shall, per the directions of the registry, manually update the P16 form previously submitted and submit it to the registry via the email for it to calculate the difference in court fee. We're very grateful to the registry for its guidance and directions. So, Your Honour, it's not much ado about nothing, but it is much ado over the claimant's obstinacy. I think that I have now amply covered all of the points arising which are before the court on the CMC and arise from Milena Friend's submissions. But if I can assist the court further, then I'm more than happy to do so.
Just one question. Do you predict that the claim amount in the counterclaim will be higher after disclosure or lower?
We think that it is likely to be higher because that would explain the obstinacy. Our point in that regard is that it is highly undesirable for the claimants to require the defendants to pay on a piecemeal basis when the defendant is in a position of having to piece its case together and incur serial amendment fees. It's wrong in principle because it's incurring avoidable expense. It's wrong in principle because there should be cooperation. It's wrong in principle because it's contrary to the overriding objective. So although we expect our counterclaim to increase in the light of disclosure, that does not absolve the claimants at all from what we say is their responsibility to respond constructively to the correspondence which has been engaged in between the legal representatives since October last year, Your Honour.
So,
sorry to interject, Your Honour. There are a few points, if I may.
Well, I don't know whether His Honour is finished with asking questions of me. He may have some supplementary questions.
no, I don't. No, I don't at the moment.
In that case, I'm obliged, Your Honour. Those are my submissions.
Thank you.
Your Honour, if I may,
yeah.
With your permission, a few points on that. In some respects, quite extraordinary submission. The defendant's representatives say they wish to generate light, not heat. Mostly, I'm afraid, what we hear from the defendant is noise, and quite a lot of it, combined with a fundamental misunderstanding of this court's rules. Its excuse, as it puts it, is that the claimant has failed to make what it terms advanced disclosure. I don't know what advanced disclosure means in that context. If it's something under the rules, I'm not sure which rule it refers to. There is no procedural right to advanced disclosure. There are court processes which deal with disclosure, and in fact, the parties have engaged in agreeing directions and a timetable precisely dealing with disclosure, which is in line with what the rules require the parties to do. There is no application before the court seeking disclosure outside of that time frame. And even if there was, the core point is that it is completely irrelevant to the payment of court fees. When a claimant files its case at the outset of proceedings, it pays its fee there and then. That's well ahead of any defence being filed. It's well ahead of any disclosure being provided. It's well ahead of the other steps of trial. And exactly the same principle applies to counterclaims. If you file a counterclaim, you do it with the proper form, you state the value, you pay the fee, and that's at the beginning of proceedings. The rules don't say a party must pay court fees whenever they feel like it. Your Honour, if I'm a claimant, I can't file and say, well, I will pay the court fee, but I don't have all of the documents yet, so I'm not going to give the court its money to incur administrative costs until maybe until disclosure is concluded. Although once disclosure is concluded, we'll have witness statements that might shed further light. So I'm actually not going to pay the court fees until after witness statements have been filed. It's nonsense. These steps occur 6 months plus into the trial process. That's why we pay court fees up front. The defendant has already made all of the arguments that you've just heard in front of the registry, and on 3 separate occasions, the registry has said, file the correct form and we will calculate the correct court fee. And that direction from the registry has been ignored repeatedly. And I'll give you one more page reference from the bundle. It's a page 123.
Yes.
Paragraph 28. So this is an excerpt from the order with reasons of Justice Sir Jeremy Cook.
Mm-hmm.
And this is from as far back as April last year. And so paragraph 28 gives us is the context in which this pleaded amount has arisen. So he says, I ordered the claimant to replead its case with a clean sheet setting out the nature of the wrongdoing. And it says, as well as setting out the exact sums it says were owed by way of commission and expenses, subject to set off for its own claim for damages. What the judge is ordering there is telling us what does the baseline of this claim look like from the claimant's perspective. The claimant pleads that. That is then adopted by the defendant. The defendant expressly pleaded those amounts in its statement of relief sought in its defence. There can be no other way to construe that than the counterclaim amount. And as the defendant has already confirmed to you, its expectation is that if anything, that amount is going to go up. They're not going to revise it down. They're going to take the baseline as an admission. And what that gives us is the minimum court fee payable. And as ever much my learned friend says, it's undesirable to pay on a piecemeal basis. Well, I'm sorry, but the courts rules say that's exactly what you do. So, Your Honour, the reference is Practice Direction 3 of 2017. Schedule 1, Article 1F, Paragraph 3. So, well, Paragraph 2, first of all, says, for a claim made by way of counterclaim, the same fee shall be payable as if the relief or remedy sought were the subject of separate proceedings. And then 3 says, where a claim or counterclaim is amended so that a higher fee would have been payable if it had been so drawn originally, the party making the amendment shall pay the difference. So the court's rules require you to pay what the stated amount in your defence is, and if you subsequently want to revise that up for whatever reason, you pay the difference then, and that's how you do it. And the simple point is that my learned friend has stressed that the defendant does not object to paying the fees. He says it wants to pay the fees. Well, then do it. It's time for the defendant to pay up if it wants to pursue its counterclaim. Your Honour, that's all we have to say in reply.
Well,
Your my learned friend raised referred to another document in the course of his reply, paragraph 23 at page 123, and I am entitled to deal with that and only that. He took the court to that and then said that what is set out there establishes his word baseline of the counterclaim. And he used the word baseline not once, not twice, but 3 times. And that neatly sums up the whole nub of the defendant's position. It should not be put in the position of responding to a baseline or knowing the baseline for its counterclaim. It should know what its counterclaim is from the information and material exclusively in the defendant's possession. Baseline, with respect, is not good enough, and that is the word that my learned friend used 3 times.
Anything else from the defendant?
No, Your Honour, because I only have a right to respond on matters arising from my learned friend's closing submissions, which were new. There was only that one point, and I've dealt with it. I'm obliged. Anyways,
I have made my decision for all the issues today. On the expert, I believe the defendant's proposal is a convenient proposal. I don't see why the matter should be delayed in relation to the experts. And the dates that proposed by the defendants shall be the dates in the case management order. Since the experts will finalize their documentation by the end of August, I don't see why this trial date should be listed for the first week or the second week of December, unless the parties are seriously unavailable for a hearing for trial in November.
Perhaps it's convenient for me to jump in there and say that the claimant is unavailable for trial in November. I've checked with my instructing solicitor on our expert's earliest available date begins in December.
What about October? This after 15 of October.
I think that might have been with October dates. I think that they'd been previously suggested, but the defendant couldn't do the dates the last week of October. So I think that's why December date was allowed on.
Could I help on that? I'm not sure that is right, and I say it with due deference, because obviously I've not been primarily responsible for the liaising of dates, but I understand, I have my instructing solicitor with me. I understand that the last half of October would be convenient.
Sorry, I've got a note from my instructing solicitor. I think that's the expert's issue as well. So I think that the expert has a lengthy trial which is running from the tail end of October to November, which is why that block of time is unavailable.
I'm grateful for the clarification. We did indeed propose a window between the 21st and the 25th of October, or the 28th of October to the 1st of November, or indeed the 4th of November to the 8th of November. But can I just again step back for a moment, because it does, it does seem really very odd that an expert should be needed for the entirety of what appears to be a 6-week trial. And I really ask my learned friend to reflect on that, because usually experts come in for their particular purpose, but don't play a role from beginning to end. So it may well be that although the expert has a case listed, there is plenty of window of opportunity within that time frame for him to give evidence, or her, for him or her, but I think we know it's a him because we know the name, for him to give evidence in this case.
As I understand it, it's more than one case. To be clear, the claimant has been keen to get this case on for a while, and the claimant wants to get this case on as soon as it can. The simple fact is that where we've landed on case management, although we'll have completed steps by November, key individuals are not going to be available during that window of time, which I think is why we relied upon the potential December windows. It may well be that, Your Honour, and it's really a matter for you, whether between, say, now and the end of the week, the parties can exchange a comprehensive list of their mutually available dates, send whatever mutually available dates there are to the court, and the court, of course, presumably will have to go and look at judge availability and so on. But once you have the parties' dates, you will then have the ability to list whenever is convenient to the court within that.
So what do you suggest?
I would suggest, subject to what my learned friend has to say, I would suggest that after we end this hearing, the parties liaise. The claimant will send the defendant its list of available trial dates, that the defendant respond to the claimant with its available trial dates, and that between anything that matches up, we send to the court, and the court lists it as appropriate within that window.
Does the defendant agree on this proposal?
Well, Your Honour, it's clearly common ground that both parties are keen to get the case listed, and I'm very pleased to hear that my learned friend confirms that. So it then becomes a question of mechanics as to how we do that. At the moment, we have what seems to be a 6-week period from the middle of October through to the end of November, when, because of claimant's expert non-availability, that period of 6 weeks is chalked out of the diary. We find that strange, and we would invite my learned friend to investigate whether there are dates within that period when the hearing can be listed, or to provide good reasons why a 6-week period is taken out of the diary. So it may be that we have no option but to go down the route proposed by my learned friend of providing a comprehensive list of available dates to the court by the end of this week. I would ask for the period to be from the 2nd week of October. I can see that maybe the 1st week of October is a bit too tight, but from the 2nd week of October through to the 2nd week of to the end of the 2nd week of December. That provides 2 full months and it enables us to avoid the obvious issues of national and international holidays.
Yeah, I agree with that as well. So you'll liaise with each other in terms of the dates from the second week of October until the second week of December. Then you will inform the courts of the dates.
Yes, Your Honour.
In relation to the court fees, which is related to the counterclaim, I find that the defendant shall pay the counterclaim amount, court fees, by Monday. By Monday, 4 February, I mean 4 March 2024. I don't see a reason for the delay, although the defendant suggests that it waits for the disclosure, but this is not how it works. How it works is when you file a claim, you pay the court fees at the same time. And when you file a counterclaim as well, you'll have to, in order for the counterclaim to stand in courts, you'll have to as well pay the court fees. And if there were an amendment to the claimed amount in the counterclaim, the defendant can always apply to the court and amend the amount claimed and pay the difference in the court fees.
Your Honour, I certainly accept the principle of what Your Honour is saying, but I would raise the time for payment. Monday, even close of play Monday, is very tight. And I would have thought that the registry would probably have allowed at least a period of 7 days or a complete week, an identifiable week, simply because I don't know where funds would need to be transferred from. It may be that they're within the jurisdiction of the UAE, in which case it's more straightforward. But to accommodate any banking issues, it's a large sum, it has to be done, may involve know your customer or additional bank authorizations, I know not. But rather than have an urgent application for an extension of time because we find ourselves in difficulties, could we perhaps suggest that it's a week later than Your Honour has indicated, namely by 4 PM on Monday, the 11th of March?
Okay. I'll
Thank you
accept.
I'm very much obliged. 4 PM on the 11th of March. I'm obliged, Your Honour.
Anything else from the parties? I think I covered all the
so.
issues.
Your Honour, will Your Honour have carriage of drafting an order, or do you want the parties to liaise and send the court an order which is drafted in line with your decision now?
I'll ask the parties to draft an order and send it to the courts.
And Your Honour, simply for court expectation management purposes, I think we will probably be submitting the order next week because of the time needed to check on expert availability. So it's simply so that the registry only expects it in the early course of next week.
Yes, no problem.
I'm very much obliged, Your
Honour. Thank you, both parties.
I'm very much obliged. Thank you, Your Honour.
Thank you.